of the law and its background is very relevant. That is why I'm briefly, I'll come to the legislative competence too. Sir, if your lordships will see that I'm not going to go through the resolutions or anything, but they're at page 171 to 185 of that booklet.
But,
and if your lordship...
one thing, I've seen judgments of this court which have cited news reports for relying on various things, and consequences have flowed from those news reports. So I, for one, do respect what the highest bodies of lawyers have to say, whether it be the Pakistan Bar Council or the Supreme Court Bar Association, most ably represented by Mr. Abid Zubairi. So if you want to file those, I mean, I would place greater credence on them than on newspaper reports which have been taken note of and judgments passed by relying thereon. So if we keep talking about this chariot perpetually ad nauseum, the two wheels of the chariot, now let us see this chariot work.
It is in my humble submission is that they are relevant.
I think competence of a law has never been, as far as
I certainly want to hear a person's point of view.
Is decided on the basis of newspaper reports. Those are other contexts.
Yes, legislative competence is a separate issue. I'm dealing right now with the independence of right now the seeming infringement.
No, but independence of the judiciary itself is, if it is violated, then the law is incompetent. Competence is not just legislative competence. Competence is also competence vis-a-vis other provisions of the Constitution.
My lord,
and what the people perceive independence to be, and more so than the people, those dealing with the law, which is the legal community. So I definitely want to see the perception of independence. I mean, it may be very independent, but people may think it otherwise, and vice versa. It may not be independent, and people may think it very independent. So yes, you don't have to spend a lot of time on it. If you can just refer to them or give it to us.
They are at pages 171 to 185. And they are resolutions that what I was able to discover were only dating back till 2018. But I understand PBC has filed something going back to 10 years ago. But there is just one aspect of those resolutions that I would ask your lordships to consider. And that goes to some of the questions that have been raised. If your lordship sees that initially in all those resolutions, the request was for this court to amend the Supreme Court rules to regulate the suo motu power and to regulate the master of roster power. That was the demand for the major period. Eventually, there has been a change in the tone and direction in the last 2 or 3 years, which has then now, in the more recent resolutions, asked for Parliament itself to directly act under 175 and 191. And presumably, the change in direction was because there was no effective response from this court on its administrative side. I'll move on, sir. Now, Justice Hilali had asked two pertinent questions, and Mr. Zahid Ibrahim had also pointed out the need to look outside. And those two questions was, one, if the CJ's power to form benches and assign cases was taken away, what would be left of the CJ's office? And secondly, how the formation of benches and fixation of cases is dealt with in other countries. Now, the answer to that first question is that there are certain specific powers and rights of the Chief Justice that are enshrined in the Constitution itself. There are about 9 that I can think of. I'm not going to go through them all, but they are there in my concise statement. Apart from the ceremonial powers, there are 9 concrete powers. The power to make benches and assign cases is not a constitutional power at all. It is not mentioned anywhere in the Constitution. In 1935, in the Government of India Act, it was indeed a constitutional power of the Chief Justice. In the 1956 power, there was a direct provision in the 1935 Act. In 1956, that power was moved to the third schedule of the 56 Constitution and made subject to rules, and then by virtue of Article 177 made subject to Act of Parliament.
This was
After
1962?
1956.
56.
Third schedule में थी power that the Chief Justice may subject to rules, form benches, etc. And that was in turn subject to Article 177.
What about the power under the Government of India Act 1935, which was the first constitution of Pakistan from 1947 through to 1956? What was how was the power there framed?
In the 1935? I'll just read the exact.
What is the section?
Ji, sir.
Read section 214.
It is 2143. Subject to the provisions of any rules of court, the Chief Justice of India shall determine what judges are to constitute any division of the court
Now kindly read subsection.
and what judges are to sit for any purpose.
Power of the roster.
Ji, sir?
The power of the roster.
Yes, it was there.
Now, actually, the power of the roster goes much further back in time. Have you seen the Indian High Courts Act of 1861?
No, sir.
Let me tell you where this power comes from and how it ends up in the judicial case law. You see, after the British took direct rule of India in 1858, one of the first laws that was made in 1861 was in relation to the power to issue letters patent to create high courts. Madras, Calcutta,
Yes.
Bombay and all that. So this is something that goes back to the very beginning of British rule in India. Now this provision, this Act of 1861, also had something to say in relation to that. Let me read out to you section 14 of this Act, 1861. Because at that time there were only high courts, right? Federal court comes in 1935. The Chief Justice of each court shall from time to time determine what judge in each case shall sit alone and what judges of the court, whether with or without the Chief Justice, shall constitute the several division courts as aforesaid. So the Chief Justice as the master of the roster is a power that goes back to the very beginning of British rule and whatever follows thereafter. This position continues for several decades until we reach 1935. In between, we have the Government of India Act 1915. वो आपने देखा है? नहीं. उसमें भी section 108 था, which was in exactly these terms. ठीक है? अब आपका आ गया 1935 का Government of India Act, where you just read out for us subsection 3, right? Subject to rules made. But the rule-making power under subsection 1, legislature had no interference with that.
Yes, sir.
Then we have the
But the Governor General did. It was with the approval of the Governor.
approval. He
Yes.
couldn't make them, he could only approve
Yes, but the approval in his discretion.
as originally contained.
My lord.
Now we come to the 56th Constitution, उसके provisions आपने हमें बताए हैं. Then we come to the 1962 Constitution, where the article takes the shape that it now has. But the 62 Constitution, as I said when Mr. Ibrahim was arguing, in the third schedule, it had a specific legislative entry for Supreme Court.
Yes.
Interim Constitution reverts structurally to the position of
Government in India.
1973 Constitution does that. Now it seems to me that if you look at the grand sweep of constitutional history, starting from 1861 onwards, the 56th Constitution, which is perhaps the high water mark of legislative interference with matters related to the power of the roster, out of those centuries long period, this is a very narrow window, hardly a few years, right? This expanse, which I think is about 150, 160 years, then culminates in the judicial case law, the case law that was referred to by Mr. Bindari, that it is the Chief Justice who is the master of the roster. Now, this is not something that the judges were creating out of thin air. This was a rule going back centuries old. It was deeply etched in the law. Now, the question to you is this. Mr. Bindari said that there is a constitutional convention that the Chief Justice is the master of the roster. If you look at the expanse of constitutional history, if you look at it in historical perspective, it is at least arguable that there is this convention, or at least a constitutional rule of ancient standing, right? The question to you is this. In our constitutional law, conventions are legally enforceable. So even if this rule is only now embedded in case law, can it not be said that it is a constitutional convention, and therefore sections 3 and 4, setting up the committee and so on, they are ultra vires, even though it's not there in the express text of the Constitution. But conventions, by definition, have to look at the much broader perspective of constitutional history, right? Looking at it from that perspective,